So welcome everyone today to the latest edition of Breaking Ground. My name is Neil Davies. I'm a partner in the insurance disputes team here at Mills and Reeve. I'm going to be joined today by my colleagues Sophie Briggs and Nathan Jones, again both of the insurance disputes team. We're going to be talking today about contribution claims arising from construction contracts. But before we do that, a little bit of housekeeping. So firstly, this webinar is going to be recorded. The recording will be available on our website, but as I understand it, everyone attending today is also going to get sent a link direct to that recording. Secondly, we're not taking questions today, but we are very happy to deal with any questions you have after the session. So if you have any questions, feel free to email any of us and we will get back to you afterwards. Okay, so housekeeping out of the way, let's move on to contribution claims. Now, these can arise quite often in a construction contract. You've got lots of parties involved in a construction project, the employer, the developer, contractors, subcontractors, various professionals and consultants. So where you've got lots of parties, there's obviously the chance that there'll be disputes between a number of those parties. Sophie and Nathan are going to talk in detail about some of the legal issues that arise. But before we do that, it's good to put these types of disputes and cases in context. I know a lot of people watching today will have dealt with contribution claims, but it's still, the context is still a good place to start before we get into the legal nitty-gritty. So let's start with a straightforward situation. A party, let's call them party A, is bringing a claim against another party, surprise, surprise, party B. Now, this could be the contractor bringing a claim against a subcontractor or the employer bringing a claim against a professional. All good so far. Well, I suppose it's not very good if you're party B because you're getting sued by A. What I mean is it's straightforward in terms of there's just two parties involved. But what if B is thinking, well, hang on a moment. There's actually another party responsible for what I'm being sued for, what the damages A has suffered. And let's call this party, surprise, surprise, party C. So often when faced with a situation like this, A will bring a claim against B and C at the same time, in which case C is already joined to the dispute and all three parties are involved. But quite often, the law will allow A in a situation like this to bring a claim against B or C for the whole amount. So in our example, A brings a claim against B for the whole amount. In that situation, it's up to party B to actively try and draw party C into the dispute or try and recover the money. Hence, we arrive at a contribution claim. And what I've described on the screen and the slide shows a very basic contribution claim. A bringing a claim against B, B seeking to recover it somehow from C. But of course, contribution claims can be far more complicated and messy than that. You can have lots more parties involved, and you can have contribution claims going back and forth between the parties. So it gets messy quite quickly and expensive. But back to our triangle, A making a claim against B, B seeking to pass it on to C. Now, there are two basic ways B can do that. Firstly, B can bring an immediate claim against C. And what I mean here is that B brings a direct claim against C, alleging that there is direct liability between B and C. Most of the time, a claim like that is brought whilst the dispute between A and B is rumbling on. So you've got three parties involved, but B bringing a direct claim against C. The other way that B can do this is via the Civil Liability Contribution Act 1978. Now, that's a bit of a mouthful. So for the purposes of today, we're just going to call it the Act. Now, B bringing a claim using the Act will allow B to either join C to the case immediately. So, for example, if A is bringing brought proceedings against B, B can use a Part 20 claim to draw C in, or B can bring a claim after the dispute between A and B is finished. One of the key factors with a claim under the Act is rather than B having to establish that there's a direct liability between B and C, what B has to do in this instance is to prove that C is actually responsible for the damages and the losses that A is seeking to recover. And it's a concept called same damage. And Sophie's going to talk about that more, so I'll pass on to Sophie.
Good morning. So I'm going to talk about the details of what you need to think about if you're faced with a situation where you need to make a claim against a third party for a contribution. Now, as Neil has mentioned, a contribution claim can either be made as a Part 20 claim as part of the existing proceedings, or as a claim under the Act, either during the proceedings or after the proceedings have concluded. So there are a few points to think about when you're deciding whether to make the claim as part of the existing proceedings or as a separate claim under the Act. Each case needs to be considered on its own facts, and there are pros and cons to both approaches. So if the original claim has been resolved before a contribution claim is made against a third party, the defendant would have to pay out all of the money in settlement or damages and then seek to recover those sums from the third party. That's not a great position to be in, so you might try to avoid that if you could by adding that third party to the existing proceedings. Adding the party to the original proceedings also has the added benefit that you've got another party to the proceedings who has an interest in defending the claimant's claim. But the counter to that is that by joining a third party to the proceedings, it also creates the risk that that party is going to use a cutthroat defence. So that's when each defendant tries to blame the other and more or less ends up throwing the other party under the bus. That's obviously not a great position. Another risk of adding a third party to the proceedings is that if the claimant fails to establish the claim against the original defendant, then that defendant may have won, but they still have the cost liability to the third party that they've dragged into the claim. You also need to have a think about limitations. So if the usual statutory limitation period for the claim against the third party has expired, and for example, in a professional negligence claim, that's usually 6 years from the date of damage, bringing a separate claim under the Act may be your only option. And then the limitation period under the Act will apply, which I will come back to a bit later. But the first thing to think about if you are going to bring a claim under the Act is the point that Neil mentioned earlier, which is whether the defendant and the third party are liable for the same damage. I'm going to go into that in a little bit more detail. So Section 1.1 of the Contribution Act provides that a person may recover a contribution for another person if they're liable in respect of the same damage. But what is meant by the same damage? So it means that the original defendant and the third party have the same liability to the original claimant. So, for example, it would be same damage if you had an architect and a design and build contractor who are both responsible for the same physical defect in a building, such as defective cladding, for example. It's a tricky area, and it's one that there's been quite a lot of case law that tells us what is considered not to be the same damage. So examples of that are an extension of time which was wrongly given by a contract administrator, and the delay caused by the contractor was not considered to be same damage. The physical defect in a reservoir and the costs of building a second reservoir were not considered to be same damage. And a building contractor's liability for flood damage as a result of defective building is not the same as the damages that were paid by its insurer. So the best way to look at it is to apply the wording of the statute, which says same damage, not same damages. And if there is an issue about whether the damage is the same, you may be best instead to add that party as a Part 20 defendant, which is fine, provided that, as I mentioned before, you're within the statutory limitation period. So the benefit of the Act is that the usual limitation periods don't apply. So just going into that in a bit more detail, according to Section 10 of the Limitation Act, 1980, a claim that is under the Act has to be made within 2 years of the date that the right accrued. So the right accrues in one of two ways. It's either going to be on the date of a court order or on the date of a negotiated bona fide settlement. And the limitation starts running for 2 years from either of those dates. So if the right accrues under an order, the 2 years begins to run from the date the damages against the party seeking the contribution are assessed, not from the date when the party is found to be liable. And for a bona fide settlement, it will be from the date that the amount to be paid is agreed. And then the final thing to think about is how the contribution will be assessed, because of course there's no point in incurring the costs for a contribution claim unless the third party is likely to contribute a reasonable amount to the pot. So the basic principle in the Act is that the court will, assuming that shared liability is established, determine the level of contribution based on what it considers to be just and equitable, having regard to the extent of that person's responsibility for the damage in question. So in determining what is just and equitable, the court will look at three key factors. Causation, so the greater the role of the parties played in causing the loss, the greater their contribution is likely to be. They'll also consider fault, so the more morally blameworthy a party is considered to be, the greater their contribution is likely to be. And they'll also consider the financial benefit. So for example, if a design and build contractor has been paid millions for a contract, they may be required to pay a higher sum in contribution than a subcontractor who's only been paid a few £1,000s for a discrete piece of work. There's no hard and fast rules on this, it's generally in the court's discretion. So now I'm going to hand over to Nathan, who is going to illustrate a couple of the points that I've mentioned with some recent case law.
Great, thank you, Sophie. So the first topic I'd like to revisit is the limitation issue, and more specifically how these extra 2 years that you might get under the Act really kick in. Now, where you've got a claim between A and B, if that claim is a good one, inherently a lot of the time A and B might decide to settle that between them. So the question for B then becomes, how does the way that I settle this dispute with A affect the time I've got to get back some of that loss from somebody else that I think is responsible? Now, the case of R.G. Carter is quite a good example of this. So in this instance, the local council contracted R.G. Carter to build the school science block quite a few years ago. Kia Business Services actually helped design this building, and later on, it suffered from water ingress. Now, what happened in this instance is that the county council decided, as they're entitled to do, to bring a claim just against R.G. Carter. Now, it was agreed at the time that the claim was a good one, so in principle, it was settled in that R.G. Carter agreed with the council they'd undertake some remedial works. What they didn't do at that stage is fully scope those works. So you can see there on the slide, it was in April that agreement in principle was reached. But it wasn't until after some further scoping, in a couple of months later in June, that the final settlement was reached, in that the full scope of the works had been agreed. And after a bit of time had passed and R.G. Carter had been able to do some of these works, they decided to make use of the extra 2 years. And so they approached Kia on the 28th of April, as it says on the slide, to ask for a bit of extra time to make that claim. And they then made that claim with the court in the September that followed. Now, as soon as they did, what Kia turned around and said, as it says there on the slide, is that the 2-year limitation period had actually expired because it had started when Carter had agreed in principle to settle it with the council. So the question the court had to deal with almost immediately was whether the limitation period had started to run. And did it start on the 16th of April when the settlement was agreed in principle and subject to contract? So Carter had agreed they were going to pay out. It was just a case of determining exactly how much. Was it the 29th of June when the scope was fully agreed? Or had it not actually started at all because the court wasn't initially involved? Now, as I'm sure some of you have come to the conclusion as I've been reading those out, it was, of course, the 29th of June. And the takeaway point from what the court has decided there is that the trigger for starting the time to claim under the Act, so that's for your extra 2 years, runs from the date that there's a binding agreement to settle. An agreement in principle, or one that's subject to contract or scoping of future works, isn't likely to kickstart that extra 2 years you might have. Now, the second topic I'd like to briefly revisit in a bit more detail is same damage, because it is, as Sophie said, quite a complex area. Now, the recent case of Energy Works is a good example of how this kicks in a larger project. In this instance, Energy Works contracted MW to do all of those things on the slide in relation to a power plant construction project. As they were entitled to do, MW then decided to bring in Autotech and subcontract them to help with some key elements of that plan. Unfortunately, because of Autotech and MW's fault, the project ran into all sorts of delays, and Energy ended up having to terminate their contract with MW. And because of all the losses they then suffered from delay and having to terminate that contract, they then decided to claim solely against MW. And what MW decided to do in this situation is the other route, which Neil touched on earlier, is dragging them into proceedings as the initial case was ongoing. So amongst quite a lot of other issues, what the court actually had to decide on is whether MW and Autotech were liable for the same damage to Energy Works for the purpose of the contribution claim that MW wanted to make against Autotech. Now, both of the claims were essentially for failure to complete in accordance with the period set out in the contracts. So, as you'll see on the slide there is some slight overlap, but only for the periods between April and August. Now, what MW were arguing in making this contribution claim against Autotech was we should be entitled to a bigger sum than that, because effectively what's happened is the delay Autotech has caused has had a domino effect and caused the entire project to fall apart. Now, what the court actually decided in this case did disagree with that view, and the court held that even though in principle it was the same type of damage, so the delays, it was only the same damage for the purpose of contribution for the period that overlapped. What MW hadn't done is prove that Autotech had any liability for termination or for anything outside the period that was in Autotech's contract for performance. So the key point to take away there is clearly it has to be exactly the same damage, and it must overlap in that both B and C must owe the same liability to A. It isn't enough to say that there was a knock-on effect. So when you're thinking about whether you could get some contribution from another party for a claim you're facing or any exposure you might have, a good first port of call is always to consider the contract and what the obligations are under those. Now, unfortunately, that is all we have time for today, and we'll do our best to respond to any questions by email. Otherwise, thank you for taking the time to join us. Please do complete the feedback form, which will be on your screens when we sign off, including the bit about how you'd like us to present these in future, whether that be in person, online, or a bit of both. Do also include any topics you'd like us to consider speaking about in future. And remember that if you'd like us to provide you with a more detailed approach, do let us know, and we're more than happy to communicate by email. Our next section of Breaking Ground will be on Wednesday, 13th of July, when my colleagues will be discussing adjudication and its place in any construction disputes. Invites for that will be coming around in due course. We do hope you'll be able to join us then, and wish you a good rest of the day. Thank you. Bye-bye.